Mike, you're responsible for our Sydney and Brisbane offices. What are the main services that you would provide in those areas?
Well, we certainly provide assistance to any practitioner looking to get a bill of costs drafted, first and foremost. And that's something that we've been doing for years, and that's our bread and butter. And of course, we support that bill of costs with submissions, if need be. And of course, similarly in Queensland, we draft cost statements and assist with submissions as well. We do operate on both sides of the ledger, and so if a practitioner considers a bill of costs that their client is being requested to pay on an inter partes basis, we will prepare objections to that bill if we consider the costs to be excessive. That's really the core of our business, but of course we do so much more than that, Paul, and a lot of that has to do with my appointment as a court-appointed cost assessor in Queensland, and so.
What does that involve typically?
Yeah, so I'll be instructed to, by both parties in a dispute, to determine the fair and reasonable costs incurred in a proceeding, and occasionally I'll be requested to undertake what's known as a default cost assessment, where a bill of costs, or a cost statement in Queensland, is presented and no objections are raised. Of course, the court ensures that there is fairness and transparency to that process, and it doesn't matter what the objections are, whether or not they've been raised. There still is required a certain oversight to ensure that there's fairness in the fees. What about yourself, Paul, in terms of the services that
we also provide bills in taxable form. I think what we have seen in recent years, though, is I suppose a recognition of the importance for practitioners to, I suppose, advise their own clients of what costs are and prospective costs. I don't know if you've ever seen the film Minority Report with Tom Cruise.
I know it well.
Where you effectively have these little jelly babies who can predict the future, the precogs, and we're like costing precogs.
That's a good way to put it.
We can effectively tell clients what the future costs are likely to be before they're incurred. They in turn can then basically inform their clients, who are often unsophisticated litigants who might not, in many cases, who haven't had any exposure to the legal system and aren't aware of the risks of an adverse cost order, for example. And that enables the client or the firm to provide full disclosure, and the client in turn to provide informed, I suppose, instructions and consent to incur those costs beforehand.
And Paul, you head up our Victorian commercial team, so you do a lot of work in commercial litigation. And I would suspect that a lot of the precog work you're referring to perhaps stems from your experience and the enormous number of expert reports you've prepared in relation to security of costs, looking forward in terms of what those costs are likely to be in a matter.
Indeed. We've done quite a bit of work in that space and provided, I suppose, expert reports and opinions as to those costs. In many cases, I think judges also welcome the assistance of an external and objective expert in guiding the court as to what those costs are likely to be.
Right.
Often, if you're, I think, a litigant or a firm that's running the case, you're more focused on the issues that are relevant to achieving an outcome.
Yes.
Rather than turning your mind to the cost implications. And we're there to assist and support our respective clients.
Indeed. And look, our co-director Charlie Kritikos heads up our mediation team. Maybe we could just touch on that for a minute and talk about the sort of services that we provide in that space. We're seeing a lot more of that in New South Wales, and the short form assessments and some of the things that Charlie brings to the firm.
Sure. Well, I think Charlie's great strength is that he's able to really look at almost any file and in turn provide an estimate of what the costs that have been incurred to date are. He then produces a short advice which sets out the main issues. And there may be, for example, disbursements which are non-recoverable. There are risks if a matter proceeds further that those costs can be limited without certification of counsel's fees, for example. There are issues that again, the practitioner may not be turning their mind to, which can have a tremendous bearing on the capture of party costs when a matter does resolve. And if that happens at a case conference, mediation stage or trial,
can be very costly, can't it?
Securing the correct orders that effectively maximise the entitlement of the ultimate client to those costs can have a huge impact on the ultimate outcome.
And look, Charlie, I suppose he deals with thousands of these matters every year, and he appears in many mediations, generally getting a very, very good result for litigants and for law firms. It's no real surprise, I suppose, that the service that we've been providing for many, many years in Victoria is taking hold in New South Wales, and we're certainly doing a lot more short-form assessment work, as we are also in the Brisbane office now.
And it's a far more cost-effective procedure as well. It's more flexible, and it doesn't mean the parties incur the expense of preparing a detailed bill.
Yes.
But the accuracy of these assessments and reports is effectively the same anyway.
Yeah, that's right. And certainly in New South Wales, where we have one matter at the moment, the application was filed 12 months ago. We're still waiting for the result in relation to a bill of costs that's being assessed item by item by the cost assessor. Whereas if we can achieve a mediated outcome with a very simple and straightforward approach, determining the quantum of the costs in a short form basis that leads to a mediated outcome, everyone's better off.
And what we find is if you're dealing with experienced litigants and practitioners, most people are on the same page. So really what they're looking for is information. Everybody understands the process. It's simply getting the information collated together so that you can have a sensible and constructive discussion and achieve an outcome that maximises, I suppose, which provides the maximum outcome for the client who's seeking to secure the costs and a satisfactory outcome for the opposing party.
Indeed, and in a much shorter time frame. Well, your costs are our priority at Blackstone, so give us a call if you need some help.